A very good morning to all my dear students. Today we are going to discuss about the drafting of an application regarding compounding of offences by way of compromise under section 320 clause 1 of the CRPC under the subject captioned as drafting, pleading and convincing. But before starting the drafting of the said application or to provide you the format for drafting the said application or to discuss the same with you, I just want to recapitulate the law regarding the compounding of offences under the Code of Criminal Procedure. My dear students, as you all are aware that every reported crime does not necessarily lead to the initiation of criminal proceedings. Under certain circumstances, it may be advisable to allow the compounding of offences and to drop the criminal proceedings if there is a settlement between the accused and the victim of the crime. Furthermore, sometimes the public prosecutor or the complainant may consider it expedient to withdraw from the prosecution, and the court may allow such withdrawal and put an end to the criminal proceedings. Under certain circumstances, the magistrate may himself desirable it to stop the proceedings subject to the certain safeguards. Furthermore, my dear students, as you all are aware that a crime is essentially a wrong against the society and the state. Therefore, any compromise between the accused person and the individual victim of the crime should not absolve the accused from criminal responsibility. However, where the offences are essentially of a private nature and relatively not quite serious, the code considers it expedient to recognize some of them as compoundable offense and some others as compoundable only with the permission of the court, meaning thereby the compoundable offenses may be divided into two categories. Number one, that is compoundable without the permission of the court and compoundable with the permission of the court. The compoundable offenses given or the list provided under the section 320 CRPC are mostly non-cognizable offenses. As you all are aware, my dear students, that non-cognizable offenses are those offenses in which the police does not have the power to investigate the matter or to arrest the accused without the permission of the magistrate. Furthermore, my dear students, as far as the Clause 3 of Section 320 provides that when any offence is compoundable under this section, the abatement of such offence or an attempt to such an or attempt to commit such offence is or may be compounded in the like manner. So from this, we may infer that an offence which is compoundable in nature, its abatement and attempt may also be compounded in the same manner or in the similar manner, as the case may be. As regard clause 4, it says that when the person who would otherwise be competent to compound an offence under this section is under the age of 18 years or is an idiot or a lunatic, any person competent to contract on his behalf may, with the permission of the court, compound such an offence, meaning thereby, if the victim is not entitled to enter into a contract, then on his behalf, his guardian or his representative, as the case may be, may file an application on his behalf for compounding of an offence committed against him, provided it satisfied the requirements laid down under Section 320 CRPC. When the person who would otherwise be competent to compound an offence under this section is dead, the legal representative, as defined in the Code of Civil Procedure, of such person may, with the consent of the court, compound the offence. So from this we may infer that in case the person who is competent to contract but at the material time he is no more or he has that at that particular point of time, then any of his legal representative may, with the consent of the court, compound such an offence. Number clause 5. When the accused has committed for trial or when he has convicted and an appeal is pending, no composition for the offence shall be allowed with the leave of the court to which he is committed, or as the case may be, before which the appeal is to be heard. Number 6. A high court or court of session, in the exercise of its power of revision, may allow any person to compound any offence which such person is competent to compound under this section. Clause 7. No offence shall be compounded if the accused is by the reason of the previous conviction liable either to enhanced punishment or to a punishment of a different kind for such offence. Clause 8. The composition of an offence under this section shall have the effect of an acquittal with whom the offence has been compounded. So the effect of the compounding of an offence is the effect of an acquittal of the accused from the criminal case. No offence shall be compounded as provided in this section, meaning thereby the offences which are not provided in the list as given under the section 320 CRPC, other offences could not be compounded as such. Now, my dear students, As far as a question regarding or an issue regarding relating to the power of compounding of offense conferred on a court under this section and the power conferred under section 482. Now, there is sometimes a confusion may arise, my dear students, regarding the invocation of 482 and 320 CRPC, meaning thereby what is the distinction between section 320 CRPC and 482 CRPC. This issue was dealt by the Honorable Supreme Court in the case of State of Madhya Pradesh versus Lakshmi Narayan, 2019 SCC Online SC 320, decided on 5th March 2019, wherein the Supreme Court, after going through the various case laws and the law point on the same, held that the power conferred under section 482 to quash the criminal proceedings for the non-compoundable offences under section 320 CRPC can be exercised having overwhelmingly and predominantly the civil character, particularly those arising out of commercial transactions or arising out of matrimonial disputes or relationships or family dispute, and when the parties have resolved their entire dispute amongst themselves, meaning thereby, even though section 320 provides that the offences which are not mentioned in the said list as provided under 320 CRPC, those offences can also be compounded under section 482, provided those offences must have or must involve a civil character or commercial transactions or arising out of matrimonial relationships. Further, such power is not to be exercised in those prosecutions which involve heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. Such offences are not private in nature and have a serious impact on the society, meaning thereby the heinous offences cannot be compounded in a court of law. Furthermore, it also says or it also provides that such power under section 482 is not to be exercised for the offences under the special statutes like the Prevention of Corruption Act. Furthermore, it also provides that offences under section 307 IPC and the Arms Act would fall in the category of heinous and serious offences, therefore are to be regarded as crime against the society and not against the individual alone. Therefore, the criminal proceedings for the offence under section 307 and of the Arms Act, which have a serious impact on the society, cannot be quashed in exercise of the power under section 482 CRPC on the ground that the parties have resolved their entire dispute amongst themselves. Further, while exercising the power under section 482 to quash the criminal proceeding in respect of non-compoundable offences which are private in nature and do not have serious impact on the society on the ground that there is a settlement between the victim and the offender, the High Court is required to consider the antecedents of the accused, the conduct of the accused, namely whether the accused was absconding and why he was absconding, how he had managed with the complainant to enter into a compromise, etc. So these are some of the guidelines to be kept in mind while drafting an application under section 482 CRPC for quashing of an FIR. So with this background, my dear students, now we would like to start with the today's topic, that is application for compounding of an offence under section 482 CRPC. Sorry, 320 CRPC. As you all are aware that the application under 482 CRPC can be filed only before the High Court of the state. But the application under section 320 CRPC can be filed before the court in whose jury in whose court the matter is pending, meaning thereby the same needs to be filed before the trial court itself. In this particular case, or the format which I am putting it before you, we have taken the jurisdiction of the Delhi, wherein I had mentioned that it is a case before the Honorable Court of Metropolitan Magistrate at New Delhi, wherein we have filed this application as miscellaneous application number so and so in criminal case number so and so of 2012, and the case is X versus Y. One is an applicant and another is respondent. Thereafter, my dear student, you have to mention the title of the application. So this application is filed under section 320 of the CRPC. Now the first paragraph, that the petition is filed or the application is filed by the complainant de facto and the accused in the above numbered case. So this application may be filed jointly by both the complainant as well as by the accused. That the above numbered case has been charge sheeted against the accused under section so and so of the IPC. Thereafter, you may put before the court that the matter related to the case has been settled and the compromise between the parties in the presence of the mediators of the councils. There is no need for the case to be proceeded with. You may annex the settlement deed or a settlement agreement if entered into between the parties and placed before the honorable court, and you may put it as an annexure number so and so in this paragraph as well. Next. Thereafter, you will put the prayer before this honorable court. Hence, it is prayed to this honorable court that this honorable court may be pleased to pass the following orders or orders. Number one, accept and effect the compromise between the parties by allowing this application dated so and so at so and so place on this day of this year. Next, pass any other order or further orders which this honorable court may deem fit in the facts and circumstances of the case. Thereafter, both the parties put their signatures and they would be verified by or identified by their respective counsel. So, my dear students, this is all about today's lecture. Hope you have learned a lot out of it. In case of any of your query, you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's lecture, I just want to apprise you with my new topic which I am going to take in my next lecture. So my dear students, my next lecture would be on the drafting of a complaint under section 138 of the Negotiable Instrument Act. Thank you very much. Stay home, stay safe, and stay healthy. We'll meet you soon in my next lecture. Thank you very much again.